This second point only arises if you reject our submission that immigration laws in section 50 does not include EU rights and obligations, including those implemented by domestic regulations. We deal with it at paragraphs 52 to 60 of our skeleton, core bundle tab 4, page 44. The question then is whether the word restriction on the period for which he may remain in section 52 of the British Nationality Act refers to a definite period during which an individual can remain, that is a specific duration or time limit, or rather refers to a conditional qualification, any conditional qualification at all, on the exercise of the right to remain, which could at some point possibly or potentially come to an end in some unknown date in the future. The respondent's position was previously that it related only to a time limit restriction. And this is clear indeed from the decision itself in this case, which can be found at core bundle tab 18. And you'll see on page 11, first paragraph. Thank you for your passport application. As you were not able to provide documentary evidence to show your mother was free from immigration time restrictions at the time of your birth, we are not able to issue a passport.
Sorry, did you say core bundle page 18?
Tab 18, page 211.
Core bundle?
Core bundle. The main bundle with the judgment and that kind of thing.
Yes, I know what the core bundle is, it's just I don't have tabs.
Oh, sorry, it's page 211.
This is the letter
This is
dated
the
8th of
decision
April.
letter. You'll see the
Yeah.
first time it says time restrictions.
Yeah.
So that's the way it was interpreted by the Secretary of State. And in accordance with the requirements of EU law, EU nationals exercising free movement rights were, as I've explained, exempted from such restrictions by Section 7 of the 1988 Act, i.e. they were exempted from the application of the Immigration Act whilst they were exercising these rights. Now that accorded with the prohibition on time-limited restrictions on EU nationals entering and remaining in other states as provided in the treaties. And I've already shown you the 1968 directive. EU law expressly provided a right to a 5-year residence permit and an entitlement to have it extended automatically. My lady will remember that. Perhaps I should take you back to it briefly. It's in the Authorities Bundle, tab 16. Page 130. 131. So just the preamble, sorry, the preamble on 130, the first two preambles. And then 6.1b, I took you to that already, an automatically renewable residence permit. But as I've said, the residence permit, as is clear from Article 4 and other authorities, is not a requirement itself. The key point is that there was an automatic renewal. So there was no time limit on your entitlement to enter or remain under EU law. And particularly also to Article 7 and Article 9, which shows it should be issued and renewed without fee. So the Secretary of State properly gave effect to that position for 17 years. She properly interpreted settled in section 11b to mean exercising free movement rights at the time of birth, which were by definition not restricted in time. And you find that in the guidance, which is at tab 39, page 631. So before 2 October, if you were exercising treaty rights at the time of the child's birth, you would show a passport showing a residence permit, for example. There are various examples here. And then at 3.3, where the evidence submitted of exercising treaty rights is only a letter from an employer or an employment contract, additional evidence should be requested in the form of pay slips, P60 or bank statements to confirm the parent is employed, etc. So you had to show that you were exercising free movement rights, and on the basis of that, it was accepted that there was no time limit on you remaining, and on that basis, you were considered settled, provided, of course, you were ordinarily resident, which you likely would have been. And then at page 632, you see the change in position after 2 October. Children born between 2 October 2009 April 2006 request evidence to show the parents had ILR or permanent residence. So the change came, it was no longer enough to show that you were exercising free movement rights, which, as I've said, were not time limited. You had to actually show that you had been given permanent residence. And just for your interest, as a result of the 2004 directive, in April 2006, regulations were adopted because the 2004 EU regulation provided for a right of permanent residence in another member state after having been there for 5 years. So that's the first time, as a matter of EU law, there was right of permanent residence in another state without having to show that you were exercising free movement rights. Now, the respondent's position now is that unless the EU national can establish an EU law right to permanent residence, i.e. the category I've just shown you, either because he fell into one of the categories where EU law provided for this right, or a right to residence could be established after 5 years, then he must be regarded as having been subject to a restriction on the period for which he could remain, even though that was not considered to be the position before 2 October. The Secretary of State therefore now reads Section 11B of the British Nationality Act as requiring something more than that you were not subject to a restriction on the period for which you could remain. Rather, you must now establish that you have an unconditional right in law to remain. He must therefore say that a restriction on period in Section 52 of the British Nationality Act includes not being subject to any potential circumstance that might lead to you no longer possessing a right to remain. In our submission, that is plainly not what Parliament intended by the words period for which he may remain in Section 11B, and we make 5 points. First, we submit that period means just that, period, duration, time. Unless, therefore, you are subject to a restriction, an explicit restriction on the time that you may stay, you are not subject to a restriction on the period for which you may stay. And we say that's the normal reading of the words, and that there is no basis for reading the words to mean something other than what they say. Our second point is that we say this is plainly what was intended when one considers the use of the same language in the Immigration Act, to which Section 52 of the British Nationality Act is referring. And indeed, the British Nationality Act replicated the definition of settled that was already in the Immigration Act. So if I can take you to the 1971 Act, that's in the 4th tab of the Authorities Bible. I can take you to 3.1b. limited or indefinite period. He may be given leave to enter the United Kingdom, or when already there, leave to remain in the United Kingdom, either for a limited period or for an indefinite period. And there can be no doubt that someone exercising free movement rights under the EU had the right to remain for an indefinite period. Then 3(1)(c), if he is given limited leave to enter or remain in the UK, it may be given subject to all or any of the following conditions. So there is a distinction drawn between a time distinction. You may be given indefinite leave to remain subject. You may be given limited leave to remain for a limited period, subject to a condition restricting your employment or occupation in the United Kingdom. Other conditions: maintain or accommodate yourself, a condition requiring him to register with the police. And then 3(2).
So, sorry, can you just tell me that, give me that submission again?
So the
So
submission
there's a distinction drawn between the time and the conditions.
Yes.
So if he is given limited leave to enter or remain, it may be given subject to all or any of the following conditions.
Yes. So there is a difference in the statute between the concept of time and the concept of conditions which may come to an end. For example, occupation.
Which would be very similar to the EU regulations, the protected person for the purpose of indefinite leave, for leave to enter and remain to work, is whilst they're a qualified worker.
Yes, that's right. But it's an indefinite. You have a right to enter for an indefinite period.
Providing you remain a qualified person.
Yes, that qualification being, as I've said,
different from time.
Yeah, different from time, and also very wide in the sense that it can include. It's not a fixed condition, so you don't have to, for example, be employed.
No, you can be accidentally unemployed.
Yeah, or you can become a carer.
Yes, all of those qualifications,
yes,
though,
exactly.
are still conditions.
Yes.
Yeah. This is all semantics, isn't it? Because you can say an EU worker can live and remain for a period limited to for so long as they are a qualified worker.
But the reason I'm taking to this is because we're trying to understand why a Parliament used for a period, and whether for a period means a definite time period, or whether it could also encompass an indefinite time period that may at some point in the future come to an end by virtue of failing to meet a particular condition.
But it'll still be a time condition.
No, our submission is it is not.
Well, I know that's your submission, but if it is dependent upon being a qualified worker, for example, or a qualified carer, or a family member, or whatever, if the qualification comes to an end, it comes to an end in a certain time frame. So the condition may end within, as it were, a time window.
Yes, it may. It may.
Well, it's always going to end in a time window, isn't it?
But there are two levels of restriction. One is a restriction as to time, and one is as to restriction as to conditions.
Yes, the conditions here don't relate to the right to remain.
Leave to enter or remain. If you're given if you're given 12-month period to enter, it may be subject also to a condition.
Yes.
Yes.
But those relate to what you may do whilst you're here.
Yes.
They don't relate to your right to remain.
They relate to your right to. Yes, they do. You both have to leave at the end of the specified period, and you can only do what you're allowed to do in the condition.
And if you're not doing what you're allowed to do in the condition, that's also the end of the time.
Well,
where you are entitled to remain.
but my submission is that the legislation...
I know that's your submission,
Yes.
but it would also help if you answer the question.
Well,
So is that correct? So if, for example, you are given limited leave to enter and remain in the United Kingdom for 12 months on condition that you apply yourself to teaching in the University of Bristol, and within that 12 months your seat comes to an end, the time and the condition have to correlate, don't they? So you would no longer be entitled to remain in the UK.
so I'm told that a breach of the conditions can lead to a curtailment of the leave by reference to a discretion. So they are distinct features, and that is our very submission.
I don't think you're listening to the question, because I think it doesn't quite answer the point. So are we agreeing violently that if, for example, under this particular provision, you were granted limited leave in terms of time and condition, that if the condition fails, then the time would also be, as it were, abbreviated? Because they both run together.
Well, as I understand from behind me, and I don't know the specific answer, but I'm told that a breach of the condition is not the same as an ending of the time limit. So ending of the time limit, you have to go. That's right, isn't it? You've got to be out of the country. If you breach a condition, that's a different problem. It doesn't mean that the time limit ends. It means that you're in breach of the condition, and it can lead to the Secretary of State curtailing your leave period.
Yeah.
And expelling.
Can you remind me where this fits in your argument?
So I am now examining the question of, in section 50 of the BNA, whether the period for which an individual may remain is a definite and articulated...
I know this is where you are in your argument, but how does the point that you've just made fit into that? That's what I'm asking.
Because the same language is used in the Immigration Act. And the Immigration Act explicitly makes a distinction between the concepts of conditions and time periods. And therefore, we say that in section 50, in referring to period, Parliament was referring to period. It was referring to a limited and definite period of time.
Time period rather than
Exactly.
period governed by conditions.
Exactly. We say, our first argument was that period, OED level, means a period of time, a distinct period of time. We say that that is supported by the distinction drawn in the Immigration Act between two different things: limitations, specific, explicit, definite limitations on how long you can stay in the country, versus conditions. And we make the point that EU citizens, or nationals, exercising free movement rights, were entitled to remain in other member states for indefinite periods, subject only to meeting the qualifications that your ladyship has mentioned.
I can see that the link, drawing a parallel between section 3 of the 71 Act and section 50 might be stronger if it did in fact use the same words, but it doesn't, does it? Because section 3 talks about a limited period, whereas section 52 talks about restriction on the period.
Well, we say that that's what it's referring to. So a restriction on the period, we go to, is it a limit on the period, or is there an indefinite period? So So is the period restricted, i.e. Limited, or is it indefinite?
And when you say that, Ms. Simon, are you saying that it could not mean that the period could be restricted because of a qualification?
Yes.
And why are you saying that?
Because we are saying that period, by reference to this, means a
I
defined...
knew that's what you're saying, but
No, because...
I'm go back to what my lord asked.
Well, I just wanted to take you to... I want to find...
No, can you go back to the question my lord asked you, which is, looking at section 50, subsection 2, there is a different terminology used. And therefore, when one looks at a period restricted, why could the period not be restricted by the end of a condition of entrance and settlement, rather than an effluxion of time?
Not sure. So if we go to 50, 52...
Yeah, thank you.
Okay, so let's go back to the British Nationality Act. Section 50.
So, without being subject under the immigration laws to any restriction on the period for which he may remain.
Restriction on the period. Yeah.
Any restriction. So why shouldn't that include conditions other than time?
Because we say that period, as provided here in 3, first, that's the natural meaning, period of time.
Yes,
like
we've
defined.
been through that.
Yeah. And second, because period here in 3.1b makes a distinction between a limited and an indefinite period.
Well, if it did have in mind that link, why wouldn't it have used the term? It could have referred to limited period of leave, limited if they'd say wish to. It seems that you must assume Parliament has used a different word for a reason. Mustn't we? And if the concept of limited leave, which is very well understood and known, is to be taken from section 3, then it's very odd that they didn't just do that.
And why did they in 31C2, 1, refer to a condition restricting his employment or occupation? So again, picking up the concept of restriction.
But that's why one would expect the words condition to be in section 52. Either a restriction on time or conditions on which he may remain. Period is plainly intended to mean period of time in this.
Well, it's a period of time, but why does you seem to distinguish between limited and indefinite periods, but it seems to me that what an EU worker has is neither. It's an undefined period, isn't it?
Indefinite.
Well, no, undefined. Indefinite suggests that it will go on forever. But the rights of a qualifying person only remain so long as they're a qualifying person, which is an undefined period, is it not? It's not indefinite. They won't be a qualifying person indefinitely. They will be a qualifying person until they cease to be a qualifying person.
That is true.
So it's not indefinite.
Undefined. Undefined.
Yes.
Undefined. And we say that this indefinite versus limited is defined. Those are the two
I mean, the fundamental issue here, isn't it, is that Simon, you are addressing us for a period of time, but it's not a fixed period of time. At the moment, it is an undefined period of time. It's certainly not indefinite, we hope, but it is undefined at the moment. But it's still a period of time.
In which case, no EU citizen could ever effectively have claimed to be second. That is the intention of Parliament in relation to this. Subject to, i.e. the new position, the Secretary of State would be successful, that really they got it wrong for 17 years, and actually it was only in 2000 that they understood that actually it meant subject to conditions, i.e. a period of time which may come to an end subject to conditions, not a defined period of time. And our submission is that what it meant was a defined period of time, i.e. a limited period of time. And we rely on this for two purposes. One, for this concept of limited. That's what it meant. A restriction meant a limited, expressly limited period of time.
I'm sorry, it's limited not merely by time under Section 3, is it? It's limited by condition, because there can be conditions restricting within that limited leave.
Yes, but I have made my points on that.
Yes, but you can make assertions. When we ask questions, we're seeking for you to take us to authorities, perhaps, for which substantiate the principles upon which you seek to rely. Instead of just going back to your first point, which is, well, we've already said that period means duration. I mean, the questions we ask are intended to assist us in writing our judgments, Miss Simer, not to make a point and argue against you.
My lady, I can only make my points. You can reject them. That is obviously your prerogative.
Yes, but we're asking you to kind of substantiate them, which would be very helpful to us.
Well, I have made, I'm not going to get any further with this. I have made my points as to what I say, that section 3.1b, 3.1c, 3.2, i.e. the distinction between the concept of conditions and time, and 3.3a, in the case of limited leave to enter or remain, a person's leave may be varied whether by restricting, enlarging or removing the limit on its duration, adding or varying or revoking conditions, but if the limit on its duration is removed, any conditions attached to leave shall cease to apply. And then again in 4, a person's leave to enter or remain shall lapse on his going to country or territory outside it, unless within the period for which he had leave, which is exactly the same language, i.e. time.
Sorry, where had you gone to then?
Paragraph 3, section 3.4 of the 1970
3.4,
Act.
thank you.
So the second line, unless within the period for which he had leave to remain, he returns to the United Kingdom. Identical language to section 50 and plainly referring to a specific period of time.
Did you say section 60?
Section 3, subsection 4.
Yes. Identical language to section 60.
Section 50 of the BNA.
50. And where in section 50 do we see the identical language in section 3.4?
So if you look at immigration laws, sorry, what am I talking about? 52, last line. Subject under the immigration laws to any restriction on the period for which he may remain. On the period for which he may remain.
So where do we see that in section 3, subsection 4?
If you go to the bottom of 3.4, unless within the period for which he had leave, i.e. the time period for which he had leave, he returns to the United Kingdom in circumstances in which he is not required to obtain. So in the period for which he had leave, not by reference to any conditions, in the time period. It can only mean time period. Can't mean anything else. And it obviously means that I should add the other point is that absolutely everything
Miss Simon, it really is not helpful to continue to turn your back when you're halfway through a submission to take further instructions. If you need time, please ask.
Look,
Because
I'm very
it is
sorry.
distracting.
I'm obviously irritating you.
No,
I don't
you're
want
not irritating us. You are distracting us from very important arguments. But it will help if you can finish a point. If somebody wants to tug your gown, then of course.
So I've been handed a note, and I want to construe the point that's been handed to you without getting it wrong. So I just want to check that I've properly understood it.
Oh, please turn your back, and we'll allow you to do so.
So the point that's being made, which I do believe we've actually made in our skeleton as well, is that my ladies and my lords should not be under the impression that once you have indefinite leave to remain, that is actually means indefinite leave to remain. Put another way, and including citizenship, any right to remain is conditional, can be brought to an end. And that is at paragraph 58 of our skeleton, which is at core bundle, tab 4, page 44. So our submission is it plainly related to time. And thirdly, we say that the judge was wrong to apply the ruling of Kummasaru in this case. And our submissions on this point are at paragraphs 56 to 57 of our skeleton. And essentially we make 2 points. First, we are going to argue that this case, that the judge below should have distinguished this case from our case. And second, we are going to argue that the court should not in any event follow it as it was reached per incuriam, namely because reference and consideration was not given to the use of language throughout the statute, the points that I've just made. So, the case you find, my ladies and my lord, at tab 22.
Thank you.
Now, in this case, which has a rather complex and difficult story in it, an individual first came to the UK in August 1973 and got a job as sub-warden of the Sri Lanka Students' Welfare Centre. But his right to remain was restricted and limited. Now, when he left the country and came back in May 75, his passport was mistakenly stamped on the false basis that he worked for the Sri Lankan High Commission and was entitled to diplomatic status. He left the country again in May 75, came back on the 2nd of June, and the same error happened. Now, he then left again and came back on the 7th of June 1978. And he was then given a time-limited restriction on his right to remain, that is, a period of 12 months. So the question before the court then was whether the 1975 errors constituted a restriction on the period, or put another way, when he had had his passport stamped with diplomatic status, he actually effectively was not restricted as to the period. You find that question at page 21 of the report. So 21 under B, the the substance of the applicant's case is that on a true appreciation of what happened, when he was readmitted on those 2 dates in 1975, when he had that mistaken stamp in his passport, although not in express terms, unconditional leave to remain had been granted. And you find the test for unconditional leave at page 17C of the report. So the test, starting just under C, whether a person is settled in the United Kingdom if he is ordinarily resident there without being subject under the immigration laws to any restriction on the period for which he may remain. Now, that was then Section 23D of the Immigration Act. It is now Section 33 of the 1971 Act. And of course, it's the provision with which we're concerned in Section 50 of the British Nationality Act. And then you see at page 21, just by E, what was actually stamped on his passport. So on his passport, when he came in May and then in June of 75, the passport was stamped with the ordinary entry stamp and wrote below the stamp, the individual wrote below the stamp the words in brackets, employed by Sri Lanka High Commission. So that's all there was on the passport. There wasn't an indefinite leave to remain or any such thing. There was just that. And that was interpreted to mean for as long as, by the court, to mean for as long as he was employed by the Sri Lankan High Commission. And I remind you that he was never ever employed by the Sri Lankan High Commission. It's a rather confusing factual scenario. And if we then go to the conclusion of Lord Justice Dillon on page 22, you see that for 2 reasons he finds that the individual could not claim that he had no restriction on the period for which he could remain by virtue of those 2 stamps in May and June 1975. So he says, in the first place, they constitute, as I read them, a qualification of the permission to enter, which is evidenced by the entry stamp. And I've taken you to the entry stamp. The applicant was granted permission then to remain in the United Kingdom only for so long as he should be employed with the Sri Lanka High Commission. That was a restriction on the period for which he might remain, which prevents him from being settled in the United Kingdom within the meaning of the Act. That is the Section 23D that I took you to, equivalent of 33 now and 50 of the BMA. So the judge held that that was binding on him and that this case could not be distinguished. So we submit that it can and should be distinguished, and our key point is that the individual was subject to a specific condition, as in that stamp, i.e. he worked at the Sri Lankan High Commission. Turned out not to be correct, but it was a condition, and that the court considered that to be a specific time-limited period. Now we say that that is at the very least more closely connected with the concept of a definite, finite period of duration. In contrast, we say no such time limit exists in relation to an EU national for the reasons that I mentioned to my lady. For example, you come here to take up services, i.e. you come here to go to the dentist. You then stay with a friend and get a job. You are then unemployed. You then take up self-employed work, cleaning in somebody's flat. You then end up caring for somebody, etc. At all these periods, you are exercising your free movement rights. we say that that can properly be distinguished from a restriction as set out in the stamp that Roehrig employed with the Sri Lanka High Commission. So, for example, in EU rights, if you have an accident at work, you then have an indefinite right. Or you retire, you then have an indefinite right. All of those possibilities could happen. And we say that this is a very specific circumstance, so that if an individual is given entry and leave to carry out a specific job, that is confined by reference to the period. That interpretation can be distinguished from the circumstances in relation to the right to free movement as a matter of EU law. Our second point is a very simple point, namely, I took you to section 3 and 3.4 specifically of the 1971 Immigration Act, which used the same definition of settled. Indeed, it's the definition of settled in the Kumarasi case. As I showed you, plainly a distinction is drawn between period of time and condition, and section 3.4 makes clear that period for the period means for the definite period of time. And it appears that there is no reference in that judgment to the rest of the statutory provisions. And a judgment that is reached without reference to relevant statutory provisions is reached pari curiam, and therefore meets the second test of the Bristol aeroplane case. You'll be so familiar with it, I hardly need to give you the reference, but it's 1944 King's Bench 718.
So, which are the other statutory provisions that they should have referred to?
Well, the section 3, I took you to 3.1b, 3.1c, 3.2, 3.3a, and crucially 3.4.
So to all of section 3?
Yes. Now it would have been
do you need time, Miss Highmore?
apologies, sorry, it's a bad habit.
It is, I'm afraid. It is distracting. Do you need time?
No, I just wanted to check that it's exactly the same section at the time of Kumarasi. And I'm told from behind me, from the real expert in this field, that section 3 was exactly the same at the time of Kumarasi.
So you say that what was missing from Kumarasu was reference to section 3.
Yes.
That's your submission
Yes.
for the per incuriam argument.
And we refer, of course, in per incuriam, of course, includes failure to refer to relevant statutory provisions, and this meets, obviously, the second test in the Bristol area.
Yes, when I asked you what those statutory provisions were, it's section 3. Yes.
Well, it's specifically 3.4 is our strongest, but if you look at them all together, it works.
All right, thank you.
So, our fourth point is that the correct interpretation is found, we submit, in the Bermuda Supreme Court case of Stevens, which you find in tab 36 of the bundle. If we go to the head note, the applicant was a Canadian citizen who'd been resident in Bermuda for some 18 years. And in April 2011, he married a Bermudan woman, thereby becoming a special status husband within Section 27A of the Bermuda Immigration Protection Act. In May 2012, he applied for naturalisation as a British Overseas Territory citizen. And that application was made pursuant to the British Nationality Act, so this Act. Of course, Kumarasi was not this Act. And then, if we go to the next page, the just about 4 lines down, the requirements for naturalisation, which were set out in Schedule 1 to the Act, paragraph 7, included C, that on the date of the application, the applicant was not subject under immigration laws to any restriction on the period for which he might remain in the territory. And then if we go to the held bit further down by the hole punch, for an application under 18.2 of the 1981 Act, the requirement was that the applicant be free from immigration restrictions on the date of the application. So the same as free from immigration restrictions on the date of birth in our case. The 1981 Act should be given a uniform interpretation throughout the territories in which it applied. And then at the bottom, read in the light of the NI, that's the guidance, not subject under the immigration laws to any restriction on the period for which he might remain in territory in 7C, meant not restricted under the immigration laws to a definite period of time for which he might remain in the United Kingdom, or as the case may be, Bermuda. And that's of course the same as for the purposes of. That's why this is the equivalent legislation in the overseas territories. And then if we go down, starting at there, were many categories. There were many categories.
Just hang on a second, let's find it. Whereabouts?
Sorry, it's about, let me count the lines, 3, 6, 9, about line 11 down from the top of the page.
I've got it.
There were
Yes.
many categories of persons generally subject to a restriction under the immigration laws. It was hard to see how someone could be present in Bermuda other than for a period, indefinite or otherwise, which might be brought to an end if certain circumstances specified by the statute occurred in relation to him. If all the persons were held to be subject to a restriction under the immigration laws, the surprising result would be that no one in Bermuda could ever qualify for citizenship. That's the point I was making, is that anybody, even someone subject to indefinite leave to remain, is subject to conditions or restrictions. In the instant case, although Section 27A of the 56 permitted the applicant to remain in Bermuda for an indefinite period, which could be brought to an immediate end if any of the circumstances prohibited, i.e. the conditions by subsection 2 occurred in relation to him, so precisely the same circumstances, in light of the NI, Section 27A was not a restriction under the immigration laws on the period for which he might remain in Bermuda, as at least in the case of someone lawfully present in Bermuda, restriction meant restriction to a definite period of time. And then if we go to page 615, you'll see at paragraph 11, the legislative condition.
Doesn't look as though Comerassi was referred to.
Well, I should have checked. No, it doesn't look like it was.
So this judgment that you've taken us to, the judgment of Justice Hellman, in the Supreme Court, it's not a Privy Council case, obviously, 2014.
Well, we say it's persuasive.
Persuasive, not binding.
Sorry, may I?
Yes, of course.
No, it is persuasive.
Yes, thank you. And can you just confirm my law's point that this seems to have been made in per incuriam as well, of a relevant decision?
Because?
Well,
because of not citing.
yes.
I don't know whether there's an obligation in Bermuda to cite English authorities. I don't know. I'm afraid I don't know the answer to that. I can find that answer overnight.
Well, they
or
appear
maybe
to
one
have,
of your lordships or ladyships knows the answer.
they appear to have cited English authorities in the Isle of Anglesey, the Welsh ministers, and the Crown Against Patents Appeal Tribunal, and also to Benyon, in fact. but not to the
I don't know
to
whether
the case that you say it overturns.
I don't know whether overseas territories' decisions are rendered per incuriam by failure to cite UK authorities. But as I say, one of you may know the answer to that question. I don't know the answer.
All right. Thank you.
May I just ask a question?
Of course.
Thank you. All right. So if we then go to page 615, paragraph 11C, I think I was just there. That is the condition, i.e. the equivalent of the settled requirement, was not subject to any restriction on the period for which he might remain. So this is in relation to BOT nationality and the British Nationality Act. And then if we go to 616, we find section 27A. At the top of the page, the husband or wife possesses Bermudan status shall be allowed to land and remain or reside in Bermuda as if he were deemed to possess Bermudan status if the conditions specified in subsection 2 are fulfilled. So pretty analogous to the EU national position. And then we get the conditions. And those conditions can, of course, be breached or ended. And then if we go to paragraph 17, we see the refusal, and no reasons were given for refusing him British overseas territory nationality. But then at paragraph 22, you see eventually they did give the reasons, and they say this means he is not considered to be, the applicant submitted by Mr. Stevens was rejected as he was has a spousal letter, but it is not indefinite as it has a stated expiry date. This means he is not considered to be free from immigration restrictions and therefore does not qualify for naturalisation at this time. And then if we go to 618, paragraph 30. We see reference to the guidance that helped the court construe the legislation, and we say equally should have regard to how the Secretary of State construed the legislation from its act commencement. And it's exactly the same. So it's exactly the same as the decision I took you to in this case of 18 April 2021. You'll recall that I took you to that decision in tab 18 of the core binding, where the reason the passport was rejected was because the appellant had not shown that his mother was not subject to time restrictions. And we see then at paragraph 30 the same provisions as you get in the Immigration Act. First, the fourth bullet down, people exempt from immigration control under 8.2, 3, 8.4, etc. However, those exempt under 8.3 or 8.4 will be technically absent. Section 8.2 consists of personal classes exempted, citizen members, etc. And then the fourth bullet, certain EEA, European or Swiss nationals. We have to read the bit, I'm sorry, you should read from 618, this is in relation to the guidance. Paragraph 7.1 of the guidance provides in material part all applicants for naturalisation must be free of immigration time restrictions on the date of the application. There is no discretion to waive this. This does not mean that the applicant must have indefinite leave to remain, or indefinite leave to enter, the following people may also be regarded as meeting the requirement. And then we have EEA nationals, i.e. they meet the requirement that they're not subject to a time restriction. They are effectively, they have not technically indefinitely to remain, but they are not subject to a period, and that's set out there in the bullet, and that's the guidance. Now, from paragraphs 33 onwards of this judgment, you get the court's analysis of the UK position, which is post-2000. And therefore, at paragraph 35, you get the application, effectively, of what is said in Regulation 8 of the 2000 regulations, as set out in the guidance. So we submit that that part of the judgment is not relevant for your purposes, because for your purposes, what you are being asked to interpret is the meaning of period in which, for which he may remain in the British Nationality Act, not the attempt to, in effect, amend that provision by way of regulations adopted under Section 2.2 of the Community Act, namely Regulation 8 of the 2000 regulations. So it is very complicated and it's a mess. But the point, for your purposes, my ladies and my lords, the material at paragraph 33 onwards concerns the position as set out in UK guidance post the 2000 regulations. Now, finally, to support the submission that potential loss of an entitlement to remain due to the person no longer meeting a condition for remaining cannot make that condition a restriction on the period for which that person may remain, I want to take you to paragraphs 48 to 49 and 51 to 52. And if you could just read those paragraphs, please. Our submission is, did Parliament, or question is, did Parliament, when it enacted Section 11B of the British Nationality Act, intend to preclude any EU citizen exercising free movement rights from having a child who was given British nationality, or rather a child born here and getting British nationality while they were ordinarily resident and exercising those rights, save where that individual could, for example, show that they'd retired, which means meeting the retirement age, so you're unlikely to retire after that, I suppose. So that would be one circumstance. The other might be illness or incapacity. But until 2006, it was impossible to have a right of residence in EU law in another state. So there were some very defined categories which would give you an EU law right of residence. But they were essentially that you met retirement age, or you suffered an incapacity during work, and therefore you could stay. So it was Parliament's intention to effectively include EU citizens settled here, living here ordinarily, working here ordinarily, and intending to make their lives here with their children. Did it intend that those children should not be able to claim British citizenship like that? We say there's nothing to suggest that that was the intention, and indeed the legislation suggests the contrary. That is because while Section 7 of the IA 88 took EU nationals out of the Immigration Act, i.e. it exempted them from those provisions, it did not provide, and I've made this point 3 times, that exemption precluded them from claiming that they were settled, as Parliament had done in relation to, for example, diplomats and soldiers. And as we've already said, had the Secretary of State wanted to do that, then he would have put that in the legislation. Fifthly, not only did the Secretary of State not do that, he did not apply the legislation in that way. Indeed, he enacted Rule 255 of the Immigration Rules, which was an entitlement for an individual to have a residence permit endorsed, this is as a matter of domestic law, after 4 years to show permission to remain in the UK indefinitely. So the intention in rules adopted pursuant to Section 3.2 of the 71 Act was that EU nationals exercising free movement rights would, after 4 years in Britain, be entitled as a matter of domestic law to remain indefinitely. And I should take you to that rule, and that's at tab 34, page 563. An EEA national, Rule 255, other than a student, that's important. So a student who's been here 4 years doesn't get an indefinite right to remain, and the family member of such a person who's been issued with a residence permit or residence document valid for 5 years, and who has remained in the United Kingdom in accordance with the provisions of the 1994 order for 4 years, and continues to do so, may, on application, have his residence permit or residence document, as the case may be, residence documents important too, as endorsed to show permission to remain in the United Kingdom indefinitely. So what was Parliament doing? Parliament, the Secretary of State, through the 1995 order and the immigration rules and the 1988 Nationality Act, was taking EU nationals out of immigration, the control of the Immigration Act, taking them out of the control of the immigration rules, I took you to Rule 5, and providing in domestic law that if you've been exercising EU free movement rights for 4 years, you get indefinite leave. Now, putting all that together, you get an endorsement of indefinite leave. If you put that all together, in my submission, it is plain that the way the Secretary of State interpreted his own legislation from its enactment for 17 years was correct. It is plain that the British Nationality Act was never intended to require EU nationals resident in the UK and exercising free movement rights to establish a permanent right to reside under EU law in order to meet the requirements of being settled. And that's what the respondent contends, and we say it's plainly wrong. Now, the judge held that this point was no good or inapplicable because a necessary precondition of the right was the application for a residence permit and for endorsement. And he referred also into the 2000 regulations in that regard. And you may or may not recall that Regulation 8 adds the requirement that you are granted indefinite leave to remain in order to be settled. And I'll take you to paragraph 46 of his judgment. Which is at Court Rundle, tab 8, page 79. Our submission on that point is that he misunderstood the point that has been made in terms of statutory interpretation. Rule 255 of the immigration rules assists the court in understanding what was intended by settled in relation to EU nationals. Plainly, the intention had not been that only if you had a permanent right to reside under EU law could you be considered free of restrictions on the period for which you may remain. The rules themselves provided for the removal of restrictions as a matter of domestic law after 4 years residence. No such EU right existed at the time, as I've said, save for retirement and incapacity. And it was not until 2006 that such a right came by reference to the 5-year period in the 2004 regulations. So to conclude, this is, my lords, a rather extraordinary case. For 17 years after promulgating the legislation, the Secretary of State, during 17 years after promulgating the legislation, the Secretary of State applied it to mean that EU nationals exercising free movement rights who were ordinarily resident in the UK were settled under Section 11B of the British Nationality Act, because they were not subject, in the Secretary of State's interpretation, under the immigration laws, to restrictions on the period for which they could remain. Nothing changed in 2000. Nothing changed in EU law, nothing changed in domestic law. The Secretary of State, however, adopted new regulations that purported to change the definition and require an individual to establish a permanent right to remain under EU law in order to establish a lack of restrictions on the period for which they could remain. But as I've said, EU law granted the rights, didn't impose the restrictions. Domestic law continued not to impose restrictions. Section 7, Rule 5, and even Rule 255. And the Secretary of State accepts now that he was not entitled to change the definitions in domestic law by using Section 2.2 of the European Communities Act and enacting Regulation 8.2. We submit, therefore, that the Secretary of State's interpretation prior to 2 October was correct, and accordingly that the appellant is a British citizen. Those are my submissions.
Thank you. So, Mr. Berry, do you follow?
My lady, no.
No. And Mr. Abdelaziz, do you follow?
Nothing from me, madam.
Thank you very much indeed. So, Mr. Blundell.
My lord, what I was proposing to do is to assist the court is to take matters in 3 stages. Stage 1 is just to begin with some very brief introductory contextual submissions. Stage 2 will be to turn to ground 1, as it's been argued today, and stage 3 is to turn to ground 2. So it's taken in the same order that my learned friend has done today, but with that brief introduction. So can I turn to that introduction first by way of context? And can I make 3 submissions by way of context? First of all, this is a case about domestic nationality law, and specifically a domestic statutory construction exercise. That exercise obviously involving an objective question for the court to determine as to the objectively ascertained meaning of the legislation. It is not as such a case about EU law, and that is because nationality is not and never has been a matter falling within EU competence, and there's nothing between us on that. It is for individual member states to determine the criteria by which individuals gain or lose the nationality of that particular state. Secondly, the second contextual submission, to the extent that individual rights under EU law arise for consideration in this case, they are relevant only insofar as it is necessary to consider the nature of the right in question, and specifically whether it is sufficient to count as settled for the purposes of the domestic statute. The fact that the source of the right is at root an EU law is, in my submission, irrelevant. And as I'll show in due course, in the course of my submissions, this court has already held that because member states are entitled to make their own provision in this field, in the field of immigration, it's necessary to start with the domestic legal framework. I'll take you to a case about that in a moment. And then, my ladies and my lords, third contextual introductory submission. The parliamentary draftsman of the 1981 Act has identified as one of the 2 relevant questions for determining whether somebody is settled, whether they are subject to a restriction under the immigration laws for the period for which they may remain. I say that's a question of substance relating to the substantive nature of any restriction subject to which a person is present in the United Kingdom. Its answer turns on the nature of the right and restriction in question, not its source, nor does it turn on the label given to the right. And we say, consistently with that approach, with that approach of substance, the substantive nature of the rights that are being exercised and the restrictions that are imposed on them, as set out in the domestic legal framework, has to be considered in the same way as any other legal restriction. So against that brief introductory background, can I go straight to ground what the appeal is being put? And you've seen already in some detail today the statutory framework, so I don't need to go through most of that again. I won't do. I'll take that as read. But perhaps it would assist the court just to have for a moment section 50 of the 1981 Act before it again, just to recap. Page 715 and 716 of the bundle. And you'll see, of course, the wording that everybody's been focused on so far. In subsection 2, references to being settled, the references to being ordinarily resident in the UK, or as the case may be, territory, without being subject under immigration laws to any restriction on the period for which you may remain. And of course, immigration laws cross-defined on page 715 as meaning the Immigration Act 1971 and any law for purposes similar to that Act, which is for the time being or has any time been enforced in any part of the United Kingdom.
Can I just remind you,
Yes.
Mr. Blundell, 2 of us are dealing with paper.
Yes.
So you're giving references to the electronic bundle. So can you...
I will get the cost references for the paper. I'm very sorry about
No,
that.
no, it's all right. It's just so that we can follow you. It's the same as
Yes.
we said to Miss Simon. If you can tell us where you are in both, because my lord has got an electronic bundle as well.
So, yes. So in the paper version, the difficulty is that the version we had when the 1981 Act was behind tab 7 didn't have page numbers.
No, but you were
But I wanted,
Paragraph 50, subsection 2, and then you said the previous,
and sorry, that's on the, so it's on the preceding page.
and this
Still
is
in the
the
definition.
immigration laws.
Immigration laws,
Yeah.
exactly my name. I'm sorry about that.
No.
I think, can I just check that in the court's hard copy bundle there aren't page numbers there either?
That's right. So this is tab 42. We've assumed we've rather assumed that you don't want it on the basis that you've marked up the paper already. But this is the number. This is equivalent of the electronic.
That would be helpful,
Okay,
Ms.
let
Simon.
me-
I'm grateful.
Thank you. Thank you very much. So, Ms. Simon was very kindly given us now tab 42, and they're numbered.
I'm very grateful to
Yeah.
you, friend, for arranging for that to be copied and handed up. So hopefully then the court can now see the pages I was referring to begin with. Page 716 is subsection 2.
Yeah.
I should really have introduced that, but you've seen this already. At the bottom of page 715, you have the definition of settled to be construed in accordance with subsections 2 to 4. So that then takes you over to page 716. You have definition in subsection 2. You also have the exemptions in 3 and in subsection 4 as well. I'll come back to it later. Then, because the phrase immigration laws is used in subsection 2, I took the court back to 715 and the definition there of immigration being any law for purposes similar to the Act.
Yeah.
So on that, which you're now extremely familiar with, can I make 5 submissions as to what that means? I'll try and keep this as brief as possible, because it is ultimately quite a short point of statutory construction. First of all, this is a broad and comprehensive definition. First, the phrase immigration laws is not limited to the 1971 Act, specifically not limited to the 1971 Act, or the regime it introduces. It includes and any law. That's, we say, a critical starting point. In terms, it introduces a wider definition of immigration laws than merely the principal act, and the use of the word any must indicate this is the widest possible ambit. Secondly, it's not on its face limited to other statutes, so it's not by the back door a definition designed to capture the Immigration Acts as expansively referred to, so the other immigration acts, the primary legislation. Is a defined term, designed to include any relevant law. It could have been limited to the Principal Act and any after-coming primary legislation or secondary legislation, but it's not. My learned friends understand it and accept that it included, for example, the immigration rules. Now, the other sources, the third point, must be capable of constituting laws, so guidance would not suffice, and indeed, it's a well-established proposition in this jurisdiction that you can't usually use the Secretary of State's own guidance to construe primary legislation. That would obviously be an entirely self-serving exercise for the Secretary of State. Now, one of the points, if I can just deal with it now, my little friend's taking you to the Bermuda Supreme Court case, where exactly that was done. The judge, in fact, said at the end of the judgment that he reached his conclusion partly to the effects of nationality instructions. We now understand what purpose that particular case is being used for. We don't have before the court the relevant case law, but there is case law from this court which says you cannot use the equivalent guidance in this jurisdiction, the immigration and nationality instructions, to construe primary legislation. So we can provide that overnight if that would be the system.
Yes, thank you.
He was obviously grappling with finding some authority, because he did mention later in the judgment he would have been assisted by expert evidence, in particular from a lawyer in the Home Office.
Well, precisely. It was a rather contingent finding in some ways that he made. He obviously reached the decision he did, but rather like Mr. Justice McCloskey in the Caporelli case, who said I would have been assisted by adversarial argument between the parties here. He's obviously had the adversarial argument, but not the evidence that would have assisted him in reaching the conclusion he had to reach. So we say, I'll come back to the Newton case in due course, so it's on the second ground that it's relied on. One has to be extremely cautious about that, notwithstanding the fact, of course, that it's not binding. just as Caporelli and Gallo are finding on this.
But you say Komarasu is binding.
We say Komarasu is
And if
binding.
it is, then the Bermudian case doesn't arise.
Exactly. And that's the end of that. I only make a submission on it because it's been raised against me today, so I have to say something about it. That's absolutely right. And of course, Komarasu wasn't referred to in the Bermudian case. And whatever else is said about the doctrine of precedent, in Bermudian law, certainly the court had regard to other English case law, and certainly it must have been that Komarasu would have been, at the very least, highly persuasive, given it was dealing with the same statutory language in the Immigration Act, which, if not in pari materia, is at least a cognate act, effectively. It's dealing with the same terms, and indeed, as you've seen from the British Nationality Act, it borrows terms from the Immigration Act. So it would have been relevant for the judge in Bermuda to have seen Komarasu at the very, very least. But perhaps I can develop with that more in relation to the second ground. The fourth submission I wanted to make is that what's encompassed by the definition is any law. That definition of law, that broad definition, is not limited to primary legislation. It includes secondary legislation, and it can include particular parts of legislation. It can include the whole of the legislation, or the regulation, or whatever particular legal instrument is being considered. There may be different laws within an instrument fulfilling different purposes. And then the fifth and final submission: what connection is needed against that background to the Immigration Act 1971? Well, all that's needed is that the laws in question be for purposes similar to that Act. We say that's a crucial, expansive linkage. The parliamentary draftsman could have said for identical purposes. We could have said one of the more limited formulations that I've indicated already. So, for example, primary legislation only, the Immigration Act only, secondary legislation only made under the 1971 Act. None of those things are said. Instead, you have for similar purposes. That evidently allows for considerable breadth in a degree of connection, and that connection is driven by an examination of overarching purpose. Now, to come to my Lord's question this morning, what's the purpose of the Immigration Act to begin with? Well, we say, and my Lord said there are degrees of abstraction here, we respectfully agree with that. The purpose of the Immigration Act 1971 is to regulate immigration in the United Kingdom, specifically by providing for the circumstances in which people may enter and remain there. You actually have the original front page of the Act and Section 1 at tab 2, so you get the introductory wording. And turn to tab 2, page 7 of the authorities book. You'll see underneath the Royal Crest in 1971, chapter 77, an act to amend and replace the present immigration laws, to make certain related changes in the citizenship law and enable help to be given to those wishing to return abroad and for purposes connected herewith. So a very broad purpose, certainly in the introductory words. Critically, what the Act begins with is not actually the leave to enter and remain regime, but as my lady pointed out, it's the right of abode. So section 1.1, all those in this Act expressed to have the right of abode in the UK should be free to live in and to come and go into and from the United Kingdom without let or hindrance. A well-known phrase, except such as may be required under and in accordance with that to enable their right to be established, maybe otherwise lawfully imposed. And it's only if you don't have that right of abode that you then get into the leave to enter and remain regime. That's subsection 2. Those not having that right may live, work and settle in the United Kingdom by permission, subject to regulation and control, and so on and so forth. Indefinite leave to enter and remain shall be treated as having been given to those in the UK at its coming into force, if they're then settled there. That was a provision, of course, which caused certain problems more recently in relation to the Windrush cohort. It was effectively regularising the position of people here, but without really an ability to be able to demonstrate them in a particular way. Not relevant for these circumstances. What is relevant is at the core of the Act, the starting point of the Act, is a right of abode. And if you don't have that, that's when you get into leave to enter and remain. Now, why that's relevant for the context of EEA nationals is that what they are exempted from by section 7.1 of the 1988 Act is not the overall scheme of the 1971 Act, but the requirement to obtain leave to enter or remain. On a number of occasions, this morning the learned friend referred to them being outside, effectively, the bounds of the Act. That's not correct. They're taken out of the leave to enter and remain regime because of the effect of the peak judgment, and indeed the effect of EU law generally on free movement. Peak simply confirmed it. But they're not taken out of the need, or they're not taken out of the right of abode position. So they're not exempted from all of that. Because they don't have the right of abode, one still needs to deal with their immigration status in some way. Now, true it is, the approach to rights to enter and remain in other EU countries, traditionally in EU law, has been dealt with somewhat differently from how it's traditionally dealt with in the UK. That's mainly because the other EU countries have land borders, so one focuses on the right to be present there. That's summarised, that analysis is summarised in the case of Volker that we refer to on our skeleton argument. I don't need to take the court there, but that explains some of the conceptual background behind what's happening here. We say, in those circumstances, the immigration EEA regime, through relevantly to this case, the 2000 regulation, is law for similar purposes. In fact, we say it's law for almost identical purposes to the 1971 Act regime, because once you take EEA nationals out of the leave to enter and remain regime, you have to regulate their presence or accommodate their presence in some other way, and that's what the regulations do. And can I just give you a reference to our skeleton? We deal with this because we anticipated it might be a question the court was interested in, but in brief form of paragraph 54 of the skeleton, page 61 of the bundle. You'll see that we refer to the judge being correct in his conclusion that the laws regulating the circumstance in which EU citizens are permitted to enter or remain are laws for purposes similar to the Immigration Act. As he concluded, the primary function of the Act is to provide for the circumstances in which persons who are not British citizens are permitted to enter and reside in the UK, what one might call by shorthand immigration regulation. The 2000 EEA immigration regulations made further provision for the circumstance in which EEA nationals are permitted to enter and remain in the UK. So we say it does follow that they are for purposes similar. Now, to the extent the learned friend relies on the European Communities Act not being an immigration statute, well, it's true that it's not specifically an immigration statute. It's not one of the immigration acts, because, of course, it was the conduit by which one gave effect in domestic law, either directly or by enabling further legislative provision to be made for the whole range of EU law. And that, as the court won't need any reminding, was spectacularly wide. Anything to do with any of the fundamental freedoms and everything else that went to do with being a member of the European Union. But of course, that simply means it has a broad purpose, the ECA. It doesn't exclude particular regulations made under the powers there, which are designed to fill the void, fill the gap that otherwise exists once you take somebody out of the leave to enter and remain regime from being in substance immigration. One does have to step back slightly here and be realistic about the purpose of the acts in question. If one simply goes down to the detail of saying that the Immigration Act is solely about leave to enter and remain, that's simply not true. It starts with right of abode. Leave to enter and remain comes if you don't have the right of abode. And then you have all the consequential provisions as well. So, for example, deportation. You have criminal provisions as well. You have various different powers to ask for things and to do things to people to do with the exercise of those powers, the usual ancillary provisions one would expect in a regulating statute of this nature. All of that you need in EU context as well in getting regulation. So we say, against that background, as a matter of the clear and explicit wording used, the definition of immigration laws is plainly capable of capturing restrictions in secondary legislation such as the EEA regs that have been made over the years, including critically the 2000 regs, which were the ones in force when this appellant was born. They set out the immigration position and deal with free movement rights and conditions and associated issues of EU nationals exercising rights under the treaties.
point is made against you.
Yes.
This formulation was used in 1971, mainly before the advent of EU European Communities Acts at the time.
Yes.
And the point is made, isn't this something which, if it was intended now to encompass subsequently, though that further legislation, that is something that would have been dealt with expressly?
In my submission, whilst obviously that's correct as a matter of chronology, that the terminology dates from the 1971 Act and is borrowed into the 1981 Act, therefore predates at source entry into the community. And the position is, at the stage at which the United Kingdom entered the European Economic Community as it was, it had on the statute book a provision suitably wide to capture the position of EU nationals. So there was no need to make further statutory amendment. Now, contrasting that, for example, with the position of those categories in section...
Well, forgive me, but there might be a need, which is, for example, it seems that the Secretaries of State themselves did not understand
Yes.
that was the effect.
Yes, and my Lord, I can't...
Saying there was no need, there plainly was a need, actually.
Well, perhaps in hindsight, there might have been a need to do something. But the point is, on terms of what's on the face of the statute book and the legal scope of the powers available, what they extend to is an objective question as to the construction of the statute. Now, I cannot stand here and pretend that the Secretary of State has interpreted that statute correctly since 1983 when it came to force. Plainly, if I am right about the effect of the statute now, if Mr. Justice Eyre's judgment is correct, then the position adopted by the Secretary of State up to the 2nd of October 2000 was wrong. And we've been clear about that. We accept it. You've seen the remedial provision that's had to be made by Parliament since then. But ultimately, what arises in this case is a question of narrow statutory construction. And if in legal fact the scope of the statutory powers was wide enough in 1981 when they were borrowed from the 71 Act without amendment to cover the position of EU nationals, then that is the answer to the point. And it may well be that the position could have been clearer. Plainly, the Secretary of State got it wrong. And again, I hope I'm being sufficiently candid about that. I can't pretend anything else. I got it wrong for a period of time, and not an insubstantial one at that. You've heard the expression 17 years many times today already. I'm not going to gainsay that. But that's not the question. The question is what the statute means. And if the powers were sufficiently broad to capture the position of EEA nationals, that's the legal answer. So I hope that's not an evasive answer. I can't, in a sense, do any better than that because I'm stuck with the position the Secretary of State adopted in fact.
No, it's not. Are you going to say anything more about the Remedial Act?
So, Lord, obviously, we've been looking at that point over the short adjournment. Our understanding of the position, but we would suggest if it's acceptable to the court, we perhaps come back on this. But our understanding of the position, to the extent I've been able to look at it from Benyon, is that where you have this sort of position with later remedial legislation, if there is a lack of clarity, if there is uncertainty in the legislation construing, then you can have regard to the later legislation as an aid to construction. Now, my primary submission, let me be clear, is that there is no such lack of clarity in the 1981 Act or indeed the 1971 Act. Well, of course, I do have ringing in my ears the admonition my Lord's just given me about the Secretary of State's own approach to the legislation over that period. Be that as it may, I say the interpretation of the Act is sufficiently clear. You don't need the 2023 Act to construe it. But if I'm wrong about that and it's not clear, then the 2023 Act would be an aid to construction which we say works in our favour. It must do, because Parliament has remedied, not by legislating to counteract the effect of Mr. Justice Eyre's judgment, and of course it's not appealing that judgment, we won, but rather to counteract what would be potentially a significant consequence for many people who thought that they were settled and British citizens in a relevant time. And of course, again, I am not standing here trying to downplay the significance of those consequences. They are significant, but won't be surprised to hear there was a lot of thinking done about that Obviously, there are the primary citizenship rights that people would assume they benefited from. They would have been given passports. They would have had access to benefits based on being British citizens, all kinds of things. They benefited through the passports on the diplomatic protection of the UK overseas. The usual things you would associate with the system. Parliament had to act, and it had to act quickly, and it did. But as I
Can you
say,
give me the tab number of the
so
Age
it is, did I say 25? No, not 25, sorry. It is tab 15.
15?
And you'll see at page 125, so the first page of the tab, the preamble, an act to make provision for immigration restrictions to be disregarded for the purposes of the DNA in historical cases, which are in practice disregarded. And then you have the insertion in section 1 of new section 50B. You have the remedial period being defined as 1st of January 83 to 1st of October 2000. And then you have subsection 2, my lady's already highlighted, and being treated as all in effect. So, if I might respectfully request permission to consider this overnight at least, in more detail, the position in terms of venue. I don't want to say something which turns out to be a partial submission, but that is, as I understand it, the approach in terms of statutory construction.
Yes, well, no doubt you'll forewarn Miss Simon, because she might want to come back on that.
Of course, of course. As I say, I hope I've made it clear. We've not relied on the 2023 Act in any way in these proceedings. We've simply kept the court up to date with what's happened, because we anticipated the court would want to know that the Act was in force. We had to do that, but we've not tried to rely on it to defend the judgment below in any way. It obviously wasn't in force at a stage at which Justice Eyre had to consider the matter. And similarly, it wasn't in force when we filed our skeleton argument, so we couldn't really rely on it there. We've not sought to rely on it since. We seek to defend the judgment on its own merits. I'm only dealing with the point because it's been raised in arguments.
And of course, it wasn't by definition in force.
No.
At the time of the hearing below.
No. Correct.
And there'd be a certain irony if a legislative response to a first instance decision affected the outcome of an appeal against that first instance decision.
Yes. There is, so far nobody's mentioned vested rights, but I'm sure that will come up at some stage, given that there is a provision here, subsection 2, which says treat it as if it's always been in force. I am being cautious for a number of different reasons about this, but we haven't relied on it. I'm only making a submission as to what the law is on this kind of scenario, because it's come up in arguments, but it's not been part of my custody case. I entirely accept that, and I'm not changing my case now.
It's something that's come from.
I think I'll take that if I can. But we'll say we'll look at it more about, so at least the court is aware of the legal positions and statutory interpretation. So I've made the point that the regulations make very similar provision for EU nationals, and in a very real sense they set out the rights of such individuals to enter and remain in the United Kingdom, just the same way as the leave to enter and remain regime does. But in a sufficiently similar way, they are dealing with the same thing, immigration status of third country nationals, albeit one particular group of nationals, which is in some ways in a privileged, was in some ways in a privileged position. We also say it's relevant to look at it in that way because of one decision of this court. That's the decision of the court in the case of Abdirahman. That is in the authority bundle behind tab 25. I just asked the court to take that up briefly, and this explains why we're going to domestic legislation. You'll see from the head note at page 231 that each of the claimants was an EEA national lawfully present, but not working and not economically self-sufficient. They made various benefit claims, and the claims were refused, and then the litigation arose from there. I can ask the court, I should say that the court in question, it was Sir Andrew Morritt, Chancellor, and Lord Justices Lloyd and Moses, and it's Lord Justice Lloyd who gives the principal judgment. Lord Justice Moses agrees and gives a short judgment of his own. Sir Andrew Morrick agrees with both judgments. You'll see, if the court turns to page 237, the claimant's immigration position. Lord Justice Lloyd sets out the position relatively uncontroversially as citizens of an EEA state, each claimant entitled to admission on production and arrival of a valid national identity card or passport, able to remain in the UK thereafter, although the government had the right to remove either of them. And in those circumstances, Mr. Blake, who acted for the claimants, submitted that each of them was lawfully present, each of them in fact residing, and accordingly, for the time being, had a right to reside. Mr. Sales, as he was for the Secretary of State, submitted that was the wrong interpretation of the relevant legislation. You'll see section 7 of the 88 Act is referred to at the bottom of the page in paragraph 11. There's then various definitions from the domestic regulations. You'll see they begin at paragraph 12. I don't need to go through all of that. And then you'll see at paragraph 15, each claimant entered the United Kingdom lawfully, this is Mr. Blake's submission, remain there without any breach, resident at the relevant time, no breach of the law involved in residing here, entitled to remain in residence unless and until action was taken to change the position or remove them. So Mr. Blake submitted, each must be regarded as having a right to do that which they were here lawfully to do, namely to reside. He then makes reference to the secondary legislation, again, reference to those provisions. Paragraph 18 of the page. As Mr. Blake submitted, there is a European law dimension to the question of rights of residence under the laws of member states. However, it is for individual member states to make their own provision as regards immigration, so long as they comply with the overriding requirements of EU law in cases where that applies. It's therefore necessary to start with the national law. So pausing there, that's why I say you start with looking at the fact and why the judge was right in his paragraph 82 to focus on the domestic law, the regulations, which effectively make equivalent immigration provision for EU nationals. Nothing, we say, remotely controversial with that. And then 19, you'll see that it seems plain to me that UK law makes a distinction between the right to reside, conferred only on British citizens, Commonwealth citizens, qualified persons under the 2000 regs, and the various additional categories mentioned in persons from abroad, refugees and so on, those with indefinite leave to remain and those whom exceptional leave has been granted on the one hand, and any lesser status, in particular that of an EEA national who is in this country having entered lawfully, has committed no breach of immigration law, but is not a qualified person, so doesn't enjoy the benefit of Regulation 14, which confers a right to reside. Logically, the EEA national has to be a qualified person to have the right to reside. It's not a proper reading, the reference to that under the UK law to extend it to an EU national who is not a qualified person. So we say you can take 3 points, 3 submissions from that passage. First of all, where a right of residence exists in EU law, it remains for the individual member states to make their own provision for immigration. Secondly, they must comply with the overriding requirements of EU law when they do that and where it applies. And critically, the court starts with the national law. So 3 submissions. And we say again, going back to the passages in the Immigration Act, section 1 that I've taken you to, that's what's happening there. You have the overarching domestic law. You then have EEA nationals being taken out of the leave to enter and remain regime only, but still right of abode, meaning what it does for them as well. And equivalent provision then being made with the domestic regulation, recognising their rights in law. And perhaps if I can just ask the court also to read over the page at paragraph 24, reference to an earlier decision of the court, and indeed again, Lord Justice Lloyd's judgment in that case, Ishmael and Barnett. And I just ask the court to read paragraph 24 with citation, and then paragraph 25. Develops the same point.
Are we to, however, note that these paragraphs that you're referring us to do seem to distinguish between a qualified person having the right to reside and not, because the case that Miss Seymour pursues is that the qualification gives that distinction.
Yes.
In these cases of the benefits and the housing entitlements, Lord Justice Lloyd is drawing the distinction between qualified and non-qualified.
Yes. Yes, he is. And of course, the position is if you're under the EEA Regulations 2000, if you're a qualified person, then you benefited from provisions of the regulation. But if you weren't, you didn't. You fall outside that regime, then again, you'd be subject to ordinary control. Now, of course, that predated the permanent right of residence as it then came into being in European Union through the Qualification Directive, development that's been referred to this morning. And of course, predated also some related developments on citizenship law. But there is one development in the thinking on that distinction between somebody who's lawfully present here and somebody who's a qualified person. And we'll get to that in the Davies case. It may be an appropriate moment to show the court that now, because in the Luxembourg court, in a decision called Davies, which is a reference from this jurisdiction, the court later held that in fact you're either here legally or you're not. And so this notion of being lawfully present doesn't seem to be entirely consistent now with the Davies decision. That doesn't make any difference for the submission I'm making, because the position still remains, if you are here, subject to exercising a treaty right, to use that shorthand, that is effectively a contingent right. And either it's contingent to the extent that Lord Justice Lloyd thought it was, that you are exercising a right to reside, or you have a right to reside, for so long as you meet the contingent condition, i.e. you work, you look for work, you provide services, whatever it happens to be, or with the slightly stricter approach of Davies, which I'll take you to now, you are here lawfully when you're exercising that right, and unlawfully for the rest of the time. The lawful residence point, which in Lord Justice Lloyd's analysis seems to mean you've entered lawfully, have been here lawfully for some period, and haven't been removed. That's not a subtlety one now sees in the European jurisprudence.
Right, okay.
So can I just take you to Davies in that case?
Yes, before you do so, Lord Justice Lloyd was saying in effect that you can't separate out a temporal permission to remain from a time defined.
Exactly.
Because the two merge together.
The two merge together,
yes.
Exactly. And you'll have seen in our skeleton, we took the two grounds the opposite way round, because it seemed to us that it made more sense to deal with the temporal point first, and then the European Union immigration laws point. But be that as it may, it's been argued in the way it has today, and we meet it in the same way.
Right.
In fact, it may make more sense simply to see them as two sides of the same coin. It's a composite question rather than dividing it, because it is a condition as a whole in the definition of settled and immigration laws in the Act. But, my lady, Davies is at tab 33, beginning at page 469. And we refer to this just for your note, no need to turn it up, in our skeleton at footnote 7. And you'll see from the head note at letter H3 that Davies was a Portuguese national who entered the UK in 1998. In 2000, she was issued with a residence permit corresponding to rights of residence. She worked until 2002, went on maternity leave until 2003, and was then unemployed until 2004, from which time she worked until March 2007, when she applied for income support. Her application was refused, but then it was effectively granted by virtue of an appeal. Now, the relevant passage I want to take for 2 is at page 506 of the judgment. And just take a look at the court to 2 short passages, the sidelines. Paragraph 48 to begin with, as the court has held on numerous occasions, the right of nationals of a member state to enter the territory of another member state and to reside there for the purposes intended by the treaty is a right conferred directly by the treaty, or as the case may be, the provisions adopted for its implementation. Grant of a residence permit is to be regarded not as a measure giving rise to rights, but as a measure by a member state designed to prove, serving to prove the individual position of a national of another member state with regard to provisions of EU law. As it's sometimes put, the granting of a residence permit is declaratory of rights rather than constitutive of rights. I think this was a point that
If the court could read 49.
I'm coming
49.
on to 49, absolutely. Such a declaratory as opposed to a constitutive character of residence permits in regard to rights has been acknowledged by the court independently of the fact that the permit in question was issued pursuant to the provisions of the Directive 68360 or Directive 90364. See the Commission in Belgium case. Again, you've seen certainly Directive 68360 this morning, and there's then a conclusion at 50 about differences between directives not justifying contention that residence permits are capable of establishing rights for the holders. Then, in the next sideline passage, paragraph 54, however, as has been pointed out in the present judgment, the declaratory character of residence permits means that those permits merely certify that a right already exists. Consequently, just as such a declaratory character means that a citizen's residence may not be regarded as illegal within the meaning of EU law solely on the ground that he does not hold a residence permit, it precludes a union citizen's residence from being regarded as legal within the meaning of EU law solely on the ground that such a permit was validly issued to him. Consequently, it must be held that periods of residence completed before April 30th, 2006 on the basis solely of a residence permit validly issued under that directive without the conditions governing entitlement to any right to reside having been met cannot regard as having been completed legally for the purpose of the acquisition of a right of permanent residence under the Citizens Directive. You have a similar conclusion at paragraph 58 as well. So the position of what was the developments in Davies was it had long been the case, going back to cases like Roehrig, Commission in Belgium, other cases too, that residence permits were seen as declaratory, not constitutive. So if you didn't have one, it didn't mean that you were there illegally. The development in Davies was to turn that proposition effectively the other way around and say, even if you do have one, it doesn't mean you've been here legally. The legality of presence for EU law is a question of substance, and it's a question of substantive fulfilment of one of the criteria on the basis of which you're entitled to a right to reside. So that is the slight difference between Davies, which is a contemporary analysis in EU law, and the position just as Roehrig was looking at it in Davies. Because he at least envisaged there was a sort of middle ground grey area of lawful presence, whereas the CJEU is looking at things in a rather binary way, it's either legal or illegal. Again, you've seen much of the domestic legislation already, so I don't seek to repeat that at any length. Can I just take the court to one or two provisions in the regulations to see what are really the key provisions that are at issue as to what is restriction and what's not. So this is in the 2000 regulations. They're behind tab 11, beginning at page 58. The court will see, after the general introduction on interpretation in Regulation 2 on page 59, you then get the specific terms of real significance in EU law, worker, self-employed person, and so on, defined in Regulation 3 by reference largely to the treaty. So you'll see there, for example, worker means a worker within paragraph A on page 60, means a worker within the meaning of Article 39 of the treaty. And the key concept of qualified person is introduced at paragraph 5. See, a qualified person, page 61, is one of those categories, again, worker, self-employed, service provider, service recipient, and so on. depends on you take into Regulation 8. Scope of the regulation starts within Part 2. And then perhaps just 2 provisions of relevance here. Part 3, EEA rights, right of admission to the United Kingdom. This is, Regulation 12 on page 64. Part 3, 12.1, subject to Regulation 21.1, an EEA national must be admitted to the United Kingdom if he produces on arrival a valid identity card or passport issued by an EEA state. That, in a sense, is the equivalent of the leave to enter provision for EEA nationals. And then over the page, right of residence, paragraph 14. A qualified person is entitled to reside in the UK without the requirement for leave to remain in the 71 Act for as long as he remains a qualified person. So we say an important, restricted, limited right, reflecting accurately the scope of EU law, as you've just seen indeed in Diaz. Clearly fulfilling a purpose, not identical to them, very similar indeed to the purposes of the regime in the 1971 Act for EEA nationals, and we say therefore coming squarely within the scope of the definition of immigration laws, and therefore setting in section 50 of the Act. I won't go through the rest of the regulations, as you would expect, and as the court may have seen in other cases, they deal with all the ancillary matters that one would expect in a regulating legal instrument in the immigration field. So, for example, position of family members, issuance of residence permits, appeals, exclusions and exceptions based on public security, health and policy. All those matters are set out there, but I don't need to go through all of that. So the key provision we say there is, of course, Regulation 14.1, which includes the operative restrictions on the right of residence by limitation to the period for which somebody remains a qualified person. Again, this is where really the 2 grounds do bleed into one another. That's more of a ground 2 point, but quite clear. If it's only for so long as you remain a qualified person, that is a restriction as to time. It's undefined at the outset, but it is limiting your time here, subject to you continuing to fulfil that requirement. So now just turn on back. Yes, and I'm grateful to Leonard Juniors. They're quite right. I should take the court before I leave this to Regulation 21. Sorry, I didn't do that to begin with. Page 67. Trying to provide a thumbnail sketch of what the rest of the regulations said. I really should have gone here. 21 deals with, it's in part 5, dealing with withdrawal of EEA rights. It's headed exclusion and removal from the UK. You'll see in 21.1 a person is not entitled to be admitted by virtue of Regulation 12, that's the admission provision, if his exclusion is justified on the public policy and so forth. A similar restriction on admission if you're not a family member in sub 2, but then sub 3, a person may be removed from the UK if he is not A, or has ceased to be a qualified person, or B, if he is a qualified person but the Secretary of State decided his removal is justified, public policy, public security, public health grounds. So that's the removal provision required when you fall outside the scope of the qualification.
And this goes back to your point that if you had right of abode, you could not be removed.
Exactly. And that's why it's wrong to say EEA nationals are outside the scope of the Act altogether. They're not. They don't have a right of abode, and therefore they can be removed. That is the one thing par excellence you cannot do to somebody with a right of abode, and that is why, of course, in recent years there's been such a proliferation of case law on deprivation of citizenship in national security cases where somebody is a dual citizen, you remove the British citizenship, you can then remove them, because before you do that they have a right of abode. You can't do it. Let's put that in wider context.
just looking at the 2000 rules for a moment, first page, they're obviously headed the immigration EEA regulations, and in the introductory wording, it's measures relating to rights of entry into and residence in the United Kingdom. And it compares that with 1971 Act, original, well, in fact, section 1,
Yes.
dealing with 1 and 2.
Yes.
Control that entry into, stay in,
Exactly.
and departure from the United Kingdom.
Exactly. It's my point that they are not for identical purposes, for almost identical purposes. Certainly similar.
Well, as you've already submitted, the wording isn't identical purposes. It's purposes similar.
Purposes similar. Absolutely. Well, that's exactly the point. And indeed, just by leaving aside the actual title and the use of the word immigration, simply by comparing the introductory preamble to the 71 Act and the 2000 regulations, one gets a real and realistic indication for the degree of similarity between the two instruments. And as I say, wholly unsurprising, because why do you need the 2000 regulations? Because Section 7 of the 1988 Act, following Peak, takes you out of the leave to remain regime. So drawing that together, the appellant's argument, as we understand it, is that this is a restriction arising from or inherent in the EU law source of the right. So it's not a restriction truly under the immigration laws because they don't extend to EU laws, and that's the argument that was rejected by the judge, the learned judge, paragraph 82 and 83. We say that's wrong in summary for 3 reasons. First of all, first submission, as indicated in opening, the issue here is the definition of settled under domestic law. Nationality law, as I indicated in opening, has always fallen outside EU law competence. So for the UK to decide what criteria need to be satisfied by someone in order to be recognised in law as a British citizen is for the UK itself. And in section 1 of the 1981 Act, one of the criteria for citizenship by birth is a requirement to be settled. And that's defined then by section 50 by reference to the absence of restrictions on the immigration laws. One might pause there and just consider for a moment the learned friend's overarching submission about the movement from jus soli, so the ability to gain citizenship simply by being born here, to the system in the 1981 Act, which is of course different. And essentially her submission, as I understand it, is that you're moving to a more restricted notion of rights of citizenship, and therefore you have to, I think in substance, construe that approach fairly narrowly. But of course it was a completely different system that was being adopted. That's what the judge said in the judgment. Ultimately you have a completely new system of nationality law in 1981. And what you see Parliament looking for in section 1 of the 1981 Act is a real and substantive connection with the United Kingdom. At the point of birth, it's through the position of the parent. But the parent has to be ordinarily resident and settled here. So it's unsurprising that there should be a requirement to look to ensure that there is no limitation on the right of somebody to be here. The closeness of the connection required to give rise to the citizenship right in section 1 is mirrored by the breadth of the need to exclude restrictions. That's not a double negative. If you have restrictions that you were able to ignore, the degree of connection between the individual parents in the United Kingdom would be more limited, and that would achieve what 1981 Act is seeking to do.
You'll have to run that one by me again.
Sorry.
No, it's just quite late in the afternoon.
I'm sorry, yes, of course. Let me try again with that. So, one is moving from a position of jus soli to a position of getting citizenship at birth, subject to a parent being either British themselves or settled here. And for settled, they have to be ordinarily resident and not subject to any restrictions. My point was that the degree of connection required under the 1981 Act is considerably greater than when the UK had a system of jus soli, which simply meant that somebody who was born in the UK would get citizenship at birth. Now you have to look at the degree of connection between the parents and the United Kingdom. And the degree of connection required is high. It's British citizenship or settlement. And settlement is defined by reference not only to being ordinarily resident, but also to not having any restrictions. So the submission I make is that that is supportive of a wide approach to excluding any relevant restrictions. In other words, if you could ignore restrictions in law on somebody's ability to be and remain here, for example, it seems to be the case my friends on in terms of EEA nationals, it would mean people whose position is contingent here are nonetheless settled and gain all the benefit of citizenship rights for their children when the degree of connection is in fact temporary. So for an EEA national, their position is contingent. It's contingent on continuing to satisfy the treaty right which they are exercising, continue to be a worker, continue to be self-employed, continue to receive services or whatever it happens to be. If a load of friends right, then the fact that they may only be doing that for a short period of time and then may become unemployed, and the Secretary of State, once they're no longer a qualified person, may be able to remove them, doesn't matter. It's a contingent position they're in, but they're still going to be able to pass on British citizenship to their children. Now we say that's contrary to what seems to be the degree of connection required under Section 1 of the Act. So looking purposively at what Section 1 is doing, that would run counter to the purpose of the Act.
How do you counter Miss Seymour's submission that if you're right, it's difficult to see that any qualified person with the leave to enter and remain
Yes.
could ever pass on British citizenship to their progeny, no matter how long they'd been here?
So the answer to that, my lady, is paragraph 255 of the rules, which was in force.
Which we've looked at, which
You've
is
looked
about the application for the...
ILR, effectively.
Yes.
Exactly. So there is a provision, the Secretary of State has made provision in the immigration rules at the relevant time for somebody to get ILR, to have their permit endorsed with indefinite leave to remain. So the position of an EEA national is not started put that so long as you exercise treaty rights, you're not going to be able to be settled. And of course, one must remember as well, this case arose in terms of the date of the applicant's birth before there was a general right of permanent residence in EU law. That's before Article 16 of the Citizens Directive came in, which provided for a right of permanent residence after 5 years, exercise of treaty rights, presence in a country, lawful residence. But even at that stage, somebody in the appellant's mother's position was perfectly able to make an application. What the judge said was, because the judge was faced with a submission with, well, she could have made the application but didn't, so in effect she qualified. He said, no, it was an important part of the rules that you made the application. So once you make the application, then you may have it granted, and at that stage you count as settled. So somebody could become settled, notwithstanding that they were an EEA national here contingently after 4 years.
And just finally, because of the time, so Miss Simon's point is, well, yes, so if you could make this application after 4 years and you get the stamp in your passport, and I'm paraphrasing very clumsily, I know, but, you know, so the only thing that's between candidate A and candidate B, whether they're born on the same day or not, is if somebody's had the wherewithal or the knowledge to go along and have a stamp in the passport.
Yes.
And she takes us to those parts and those provisions which says, well, you don't need this permit to be legally here. So if you can answer that now shortly,
Yes.
that's fine. If not, we'll come back to it tomorrow, because I do think it's something that
Yes.
we do need to
So, my lady, then let me try and answer that now. If I can.
base out.
So what I say in relation to that is, first of all, true that you don't have to have the permit to be legally here. Equally, recall what I showed the court in Davies, even if you've got the permit, it doesn't demonstrate legal presence. And actually, when you combine that with this provision, the requirement to have somebody apply is important, because it enables the Secretary of State to verify that they have, in fact, been lawfully here exercising treaty rights for a period of 4 years, rather than perhaps here for most of that period, but not the entirety of the period. It actually enables the checks to be made. And of course, at this point, it was a provision solely in domestic law. So the Secretary of State was not required to do this by European Union law. European Union law didn't require at this stage any recognition of permanency, save in the very rather exceptional circumstance that the learned friend referred to, which we agree with, where you are, for example, retired or incapacitated. There were certain limited permanent residence rights there. But generally, this was the Secretary of State doing more than needed to be done. And if the Secretary of State was doing more than needed to be done, he was entitled to say, I'd like to just check that you have actually been here exercising treaty rights before I give you settlement, ILR, and all that that entails. Citizenship, access to benefits, all the rest of it. Because that is a really valuable right. I've avoided making submissions, sort of qualitative submissions about the value of rights, because it's very qualitative, it's quite a subjective analysis. But citizenship rights are valuable. They enable access to an awful lot of things that are of real benefit to people who are otherwise subject to immigration control. So I say it's a combination of those two things.
All right, is that a convenient moment?
My lady, yes, of course.
How much more have you got?
My lady, not a huge amount. I will endeavour, and I think I can, to cut down my submissions overnight. On certainly the first round, my submissions on the second round are shorter in any event. I've already covered them to some degree. I certainly wouldn't envisage being more than an hour tomorrow. I hope substantially less.
And then we have Miss Seymour. So it looks as though we will finish by lunchtime. It's not in any way necessary, because we're here obviously for the day with nothing listed afterwards, but it does look as though lunchtime may be realistic. All right, thank you all very much.